Good morning and happy Thursday. My name is Michael Leeserman here with the Trial Guide's Tip of the Day this September 28th, 2023. Today's tip comes from Case Analysis, Winning Hard Cases Against the Odds by Jim McComas. And here to read the tip is Jim McComas himself. Thanks for being here this morning, Jim.
Sure, Mike. Thanks for having me. By the time of trial, we know a vast amount of information about our case, but we'll only be able to present a small portion to the jury because of rules of evidence, because of availability, because of unforeseen circumstances. But the core insight is this. Within that small portion that goes to the jury, only a few facts and circumstances will determine the outcome for either side. Well, my dear wife has drawn this chart here. Everything in black we will know, but only what's in blue will be before the jury. And in that box, this small red dot will contain what I call outcome levers. An outcome lever is a fact, a piece of evidence, a circumstance having nothing to do with the evidence or any other thing that in and of itself can determine outcome for one side or the other. The important ones to look for are the ones that aren't in the evidence, because as lawyers, we're trained to look at the evidence. Take race. Depending upon where you're trying the case, the racial makeup of who got hurt and who did the hurting may make all the difference in the world, even though neither side is supposed to address it in court. Well, we can't afford that. If we're on the losing end of the racial analysis, we have to address it in court, make it right. Another example would be high-profile cases. I once tried a case where 90% of the venue agreed that my client was guilty going in. But after a rigorous voir dire and a trial in which we had a surprise that no one had heard in the last number of years when the publicity was building up, it resulted in a acquittal for murder. So that's the concept. Once you've identified the outcome levers, theirs and yours, you then work to minimize theirs by exclusion, by evidentiary limit, by anything you can do. And you take yours and you inflate them and make them as large and effective as possible.
This seems very wise. The idea, the first part of that is just a mistake that I see lawyers make all the time. And that's, I would call it the curse of knowledge. I didn't make up that phrase, but the idea that we come in knowing so much and we want to just spill it all, and the jurors don't care about most of it. And then you're taking a step further saying, not only is there this whole big box that you drew of things that don't need to go into the case, figure out what is an outcome lever, what makes a difference, what helps you win, right?
Exactly. What in and of itself, I really think that's the key way of putting it. What circumstance or evidentiary theory or claim in and of itself can determine the outcome? And there always are between 3 and 6 for each side in every case. And so identifying those and then gearing your motions work, your investigation in civil cases, depositions, discovery, all of that to expanding what's good for you and narrowing what's good for them. That's how hard cases are won against the odds.
Wow. Very powerful idea. Thank you so much for sharing your wisdom with us today, Jim.
Thank you, Michael.
Let's take a deep breath together and be grateful to be alive this Thursday. May the work we do today help to reduce suffering in the world, reduce suffering in the lives of our clients, in our lives, and in the world. May our efforts help to repair the world. May we fiercely and compassionately advocate for our clients, champion their stories, and do so from a place of compassion and wisdom. I'm going to ring a bell 3 times now. This can take you into a meditation practice, a prayer practice, or just remind you, wake up, it's Thursday. Go out, do good things, and have fun while you're doing it.